Hey guys, welcome to this video. This is John Watts. I'm a consumer protection lawyer, and we're going to talk about this FDCPA, Fair Debt Collection Practices Act case. And this is from 2015. It's the Hart versus FCI lender. I want you to see this for a couple reasons. One, it talks about debt validation, which is under Section 1692G. Now, normally when we think of debt validation, and there's lots of questions about it, it's more of, well, what must a collector do when you request validation? This is actually kind of taking a step back and just saying, when do they have to send you the debt validation notice? Just the initial notice. And so we're going to look at that. I also want you to see how it's pretty subtle, but the debt collector here misstates the law. And the court definitely calls them on the carpet about that. And then the final reason I want you to see this case is that we see the debt collector's very common argument. They go, come on, what's the big deal? I mean, kind of a technical thing, no harm, no foul. This is not what Congress is concerned about, these little minor details. And the Second Circuit Court of Appeals says, wait a minute, this is a big deal. And you did violate the law if, what is being alleged here is true. Now, this is before kind of the madness of standing became the rage in federal court, so you won't see anything about that in this case. Understand, if you've watched some of our other videos where we talk about standing, this type of case probably would not survive in a lot of courts due to the arguments of standing. So I would bring this in state court rather than federal court, but we're not looking at it for standing. I just want you to see when this law is triggered, how this debt collector violated it, and how the court said that violation matters. So let's go ahead and jump into this. So what I've done is the yellow will be when the court's speaking, there'll be green when it's the plaintiff, Mr. Hart, and it'll be light blue when it's the debt collector speaking. So we've got the 1692, that's the FDCPA. There are some notice obligations triggered by the initial communication with the consumer in connection with collection of any debt. That's going to be important here in a moment. Now, the district court judge, granted the motion to dismiss and threw the case out and said, look, this really isn't a debt collection letter. This is what's called a transfer of servicing informational notice under RESPA, Real Estate Settlement Procedures Act. So basically, when you get a new servicer, that new servicer will write you a letter and say, hey, we're taking it over. Here's our address. Don't send payments to the previous server. Send them to us. And they have to do that under RESPA. So the trial judge says, that's what this letter was all about. It really wasn't any type of debt collection letter. So it says this was not a communication sent in connection with the collection of any debt under the FDCPA. The appellate court says, actually, we agree with the consumer that he has alleged that this letter is in connection with the collection of a debt, thereby triggering the initial notice requirements under 1692G. And we'll see how this debt collector botched those notices, okay? So they say we vacate the judgment, remand for further proceedings. So we have this letter sent to him by FCI, the debt collector, after FCI assumed loan servicing obligations and he was in default, which that's important because you have to be in default for the company, the new company that gets the debt, to be considered a debt collector. All right, so we'll scroll down and this is the notice here. So it's on the third page. It says, important notices, please read. This is an attempt to collect upon a debt. Pretty straightforward. And then I have this in red because I want you to notice this, and we'll come back and look and see what does the actual law say. It says this debt will be assumed to be valid unless you dispute its validity within 30 days after receiving this notice. Okay. So what does the consumer say? Consumer says, hey, they violated the FDCPA by sending the letter and failing to identify the current creditor and misstating the debtor's rights. And really, we're going to focus on that, misstating the debtor's rights. The debt collector responds by moving for a motion to dismiss and says, look, you haven't stated a claim. There's no way you can win because it's clear this was not an initial communication in connection with the collection of any debt. And the district court, the trial judge, agreed and threw out the case. And so then the consumer appealed. So again, the consumer says, excuse me, this was in connection with the collection of a debt. The debt collector says, number one, no, this is really just to comply with RESPA. And then they had a couple other arguments, which won't be important for us because the court ultimately doesn't reach them. So we'll focus on this argument number one. It's just to comply with RESPA. And so the court says, okay, well, let's look and see what's the whole point of the FDCPA. It's to eliminate abusive debt collection practices. And so that's focused on protecting consumers, but also to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged and to promote consistent state action. So in other words, we want to protect consumers and we want to make sure that if you are a debt collector and you're playing by the rules, that you're not at a disadvantage. So think of a football game, assuming we're going to have any football this fall. If one team has 13 players on the field and you have 11, well, you're at a disadvantage. So we need to penalize that team that's breaking the rules. And so a goal of Congress was to address not the isolated, not the scattered, not the happens once a year, but the recurring problem of debt collectors dunning or collecting the wrong person or attempting to collect debts which the consumers already paid. So it's a big problem. Well, how do we solve that problem? Well, 1692G is one way to do it. And 1692G, you might think of this as this is sort of a way to resolve disputes before you get into court, if you choose to take advantage of it. So this is called validation of debts. Requires debt collector and by the way, the debt collector FCI here, they admit for purposes of this argument that they are a debt collector. So we're not arguing about that. So a debt collector has to furnish written notice conveying certain information, that's the 1692G notice, to the consumer upon the initial communication collection with the debt. So when that first communication, however that comes, when that goes to the consumer from the debt collector attempting to collect the debt collector has a choice. Include the 1692G notice in that communication. So if you're going to send a letter that's trying to collect the debt, just put the 1692G notice in there. Or you can send a separate written notice within 5 days. And then the required contents relate both to the particular debt and to the rights under the Act. So they've got to tell you the amount of the debt, the name of the creditor, and your right to dispute the debt's validity. And if they mess it up, they violate it, the FDCPA grants a private right of action to a consumer who receives a communication that violates the Act. So pretty straightforward. So what does the debt collector do? Debt collector says, hey, look, we agree, we're a debt collector. We agree this was an initial communication, but we don't agree that this was a communication in connection with the collection of a debt. So let's look at the letter. The debt collector says, we weren't trying to get him to pay his debt. We're just telling him about this transfer of servicing. And since it was not in connection with the collection of debt, we had no obligation to provide the complete recitation of debt-related information. Now, let me just stop there. I think when a debt collector, first of all, if they include the 1692G language, they got to get it right, whether they were obligated to do it or not. If they put it in there, they have to do it right. Now, this case doesn't turn on that, but just keep that in mind if you ever run into that situation. So district court accepted this argument up here. And the district court said the letter did not attempt to induce, and we'll see that word later. There's a reason the judge used that. Did not attempt to induce Hart to make a payment, but rather assumes he will be making payments and directs where he should send them. It's informational, does not reference an amount, does not threaten to take action. And the document itself establishes it was not sent in order to induce him to make a payment. That's kind of an odd statement. And the court points this out because, remember this, the document itself establishes it was not sent in order to make a payment. Well, the document itself says this is an attempt to collect upon a debt. Pretty straightforward. The trial judge just ignores that. And the Second Circuit Court of Appeals says, well, look, we've never really addressed this issue specifically. And so here's our conclusion now. Whether communication is in connection with the collection of a debt is a question of fact to be determined by reference to an objective standard. So subjective standard will be, well, what do I think about it? But objective says we're going to look at from a sort of a least sophisticated consumer standpoint, not just what was in the brain of the debt collector when they sent it. So they say we must view communication objectively, asking whether he's plausibly alleged, that's the standard in a motion to dismiss case, plausibly alleged the consumer receiving could reasonably interpret it as being sent in connection with the collection of a debt, rather than inquiring into the sender's subjective purpose. So sender's subjective purpose would be, well, what did the debt collector have in its mind when it sent the letter? And they say, look, this type of approach is consistent with the goal of protecting consumers. If a consumer receiving a letter could reasonably understand it to be a communication in connection with the collection of a debt, then the consumer is entitled to protections. And we have to remember the FDCPA is remedial in nature and must be construed in a liberal fashion. So we're not going to interpret it real tightly. We're going to interpret it broadly or expansively because that's what we do with what are called remedial statutes. So here's the debt collector. They say, well, look at what the Sixth Circuit and the Seventh Circuit, what they say. There must be an attempt to induce the borrower to pay, not just give you information. So here's a case that's Litton loan. FDCPA does not apply to every communication, but that a communication made to induce a debtor to settle her debt will trigger the protection. And then we have this, I guess it's Gurdin case. It says an animating purpose of the communication must be to induce payment by the debtor. Now the consumer says, well, that's fabulous what the Sixth Circuit and Seventh Circuit do. But let's look at what the Second Circuit does, because this case is in the Second Circuit. Points at district court, which is the trial judge level, in our circuit, recently construed the phrase far more flexibly when it rejected the information/inducement dichotomy, and it reasoned in connection with is synonymous with the phrases related to, associated with respect to, and does not necessitate any inducement element. So the consumer is saying, no, you don't have to induce the consumer to do something. You just have to, that collection letter just has to be related to or associated with collection for it to count as an attempt to collect the debt there, which would then trigger the requirement under 1692G. So they say, well, look, we don't have to figure everything out because we have no difficulty in concluding that an attempt to collect a debt, remember, we come back up here. The letter itself said, this is an attempt to collect upon a debt. So they say, which we believe the letter was, qualifies as communication in connection with the collection of any debt. And then, I didn't highlight this part, but we see few types of communications as more obviously in connection with the collection of debts than attempts to collect debts. Okay, and they cite an 11th Circuit case. And then points out Congress identified abusive collection attempts as primary motivation, and the remedial purpose of halting abusive practices and giving debtors adequate information. So say, look, this is an attempt to collect a debt. It refers to his debt. It says, here's where you mail your payments, including all past due payments, specific address. It references the FDCPA, and it warns that he must dispute the debt's validity within 30 days or his debt will, quote, be assumed to be valid, end quote. Finally, most importantly, the letter in its 2-page attachment emphatically announces itself as an attempt at debt collection. This is an attempt to collect upon a debt, and any information obtained will be used for that purpose. So they say, look, a reasonable consumer would say, hey, I believe you. I believe the warning. I believe that you're telling me I got to do something within 30 days. And I believe you when you tell me you're trying to collect a debt. So it seems pretty easy. Well, what's the debt collector's response? Let's say, look, because it's this RESPA required notices, that tells you the purpose was merely to convey information. And it doesn't discuss the current status of the consumer's debt, the amount due, and it does not explicitly demand payment. And then they say, and this is sort of the subtle thing about whose perspective are we looking at? So maybe the debt collector is being truthful when they say, we weren't trying to collect a debt when we sent this. But notice what I have here in red. Even if it could be ascertained that the debt collector's sole intention, excuse me, in sending the letter was to comply with RESPA, we are hard put to accept that a reasonable consumer receiving the letter would necessarily understand that the debt collector did not send the letter in connection with the collection of her debt. So we see no reason the letter could not serve more than one purpose in any event. And so then the debt collector comes back and says, well, it's a little bit circular to say that when we put in the letter an attempt to collect a debt, renders a letter a communication in connection with collection of a debt. And the debt collector says, look, the law requires us to disclose in the initial written communication that we're attempting to collect the debt and any information be used for that purpose. So the debt collector argues it'd be unfair to consider this required language as evidence it's actually an attempt. But here's the court's response. But a debtor receiving the letter has no reason to know that the language is required or to believe that the language mandated by 1692E, which that's E11, is that what's called the mini Miranda. This is attempt to collect the debt, any information used be or information gained be used for that purpose. It's no reason a consumer would think they could be safely disregarded. The letter clearly announces itself as an attempt to collect a debt, and its other text only emphasizes the plausibility and gravity of that. We see no reason why we should not take it at its word, nor any reason a consumer would or should fail to credit the clear language of the document. And this is really important. While it may be unfortunate for debt collectors that the use of a defective notice helps give rise to an obligation to provide a proper notice, what's the solution? Is the solution to say, ignore the law, don't let us get sued? No, they say solution is to fix your defective notice, okay? So when you're sending out a defective notice, the answer is fix it, okay? Not change the law to make it protect a defective notice, but fix a defective notice so it complies with the law. And then notice what's highlighted here and that I have in bold. A defective 1692G notice pose particular dangers for consumers. And this is where the subtle misstatement of the law comes in that letter that we've looked at. The letter states the debt will, after 30 days, be assumed to be valid. A consumer who fails to timely act upon the letter might believe she has forfeited her right to challenge the accuracy. But under 1692GA, which FCI paraphrased incompletely, such an unchallenged debt may be assumed to be valid only by the debt collector, leaving the consumer free to contest the debt with the lender either directly or in courts. By misleading the consumer into believing she had forfeited her right to dispute the validity of this debt, then the debt collector is frustrated a major objective of the FDCPA. Now, let me show you this. We'll scroll down. It's in the footnotes. So here's 1692G. Then 5 days after initial communication, connection of the debt, you have to get this written notice, the amount, the name, the statement that unless the consumer within 30 days after receiving notice disputes the validity of the debt or any portion thereof, the debt will assume to be valid by the debt collector. That's not what they said. right? They said up here that it will just be presumed to be assumed to be valid, like end of story. No, it's assumed to be valid by the debt collector. Those are two different things. So here's the final argument of the debt collector. It's kind of like, okay, you got us on that. We violated the law. But look, they say Congress point out these really, really bad things that debt collectors do. And so the argument seems to be because Congress targeted specific methods of collection, which do not include communications such as a letter, then the notice requirement should not be triggered by the letter. So basically they're saying, Congress talks about like making these terrible threats against people, abusive language, lying to people. So what we did is no big deal. And the court says plainly sending a letter such as this letter is not as aggressive making late night phone calls or some of these terrible practices, but that Congress cited the industry's worst practices when passing the FDCPA does not limit the statute's purview to those practices. When the text reaches well beyond, debt collector provides no reason to believe Congress did not intend the FDCPA to offer broad protection to debtors, or that a debt collector's failure to provide the required 1692G notice should be excused as no more than a, quote, de minimis violation. So de minimis just means very small, almost meaningless, which is what just for the lawyers that are watching this who do this type of work, they'll know this. Every single case you bring against a debt collector, what you get back from the other side is, oh, well, we didn't do anything wrong, but if we did, it's just a de minimis technical violation. Whenever they get in front of the judge, they go, this is no big deal. This is just a technical de minimis violation. They love that expression, which is why this case is so valuable. So it's saying debt collector gives no reason that they should be excused as no more than a de minimis violation, one from which act would not protect consumers. They say, again, broad remedial intent in adopting the FDCPA. So the complaint was proper. It said the letter was communication in connection with collection of a debt. Therefore, the district court made a mistake. And so we get down to the conclusion, and I'll just highlight this. They vacate the judgment, remand it for proceedings consistent with this opinion. So again, I want you to see this case to really understand, when does that 1692G notice have to be sent out? And then if you have a notice, and if you have any debt collection letters, you should have the notice. Compare your notice carefully with what the law actually says. So this is the actual law right here. Okay, and we have a video. It should be linked up here, put in the description. I did like a, I don't know, 17 or 18 part series where we go through the literal text of the FDCPA. And so we have a video that's on 1692G where you can see the entire text of the statute and what it means. And so going back to why wanted you to watch this video. One, when does 1692G notice have to go out? Number two, check it to make sure that it's actually what the law requires. I mean, this is a pretty subtle thing. This says the debt will assume to be valid by the debt collector. That's what the law says, but the letter just said it'll assume to be valid. And then number three, to expect and to be prepared to fight back when these debt collectors, once you catch them doing the wrong thing, when they say, well, come on, what's the big deal? I mean, this is just a minor violation, nothing here to see, just ignore it. Now, they know they can't win that directly, so they kind of use that argument now with standing. And you can see a bunch of videos we've done on these case decisions where we talk about standing, where they'll say, you don't have enough in the way of concrete harm to make the doors of the federal courthouse open up so your case gets kicked out. So you have to look at all that. But appreciate you guys watching this video, and I'll be doing more videos on the validation type requirements. And I can certainly tell you what the law is. And I could say, here's my view of it. But I also want you to see directly from different courts, even when courts disagree, what they say about validating a debt. What happens when you send a request to a debt collector? What must it send you back in response? So if you like this type of video, just subscribe to our channel and you'll be notified. Maybe click the notification symbol so that you'll get a notice when we release a new one. We try to release a video every day, and we'll do these case decisions once or twice a week. Okay, have a great day, guys. Bye-bye.